Sylvester was discharged.
Yes,
I beg your pardon.
He's not well, so
he's not well. Yes,
Dr.
Sylvester Anemana, who was discharged because he was not well.
Absolutely.
So I mean, the court decided that they were going to discharge him, and he was not going to be involved in this.
Intention to file a null procedure.
Yes, exactly. And then there is Richard Jakpa, as well. Richard Jakpa as well,
businessman,
who is a businessman. Yes. And I believe that in the case of Alhaji Collins Dauda as well, there was one of the witnesses, or one of the people involved, one
Alhaji
of the Ziblim Yakubu, who
he is also not well.
Who is also not well.
But the one of them has passed on, in fact, the Saglemi, that's the Saglemi.
In the Saglemi Affordable Housing Projects, one of them, passed on, of
Albert Kolkanas.
Kolkanas, yes, of blessed memory. Yes,
so
yes.
In that case, instead of 5 accused persons, you have 4 now.
4 accused persons now. So all of that has been going on. Richard Jakpa has been trending since yesterday because the CDS, he subpoenaed the CDS to appear and testify.
Yes.
The Speaker of Parliament is here to come and testify as well.
On the 8th of October.
Interesting. So what has been happening, in all of that?
So as we do know, last week there were no sittings. Tuesday and Thursdays were no sittings. So the court had made it a point that those 2 sittings that were lost would have to be dealt with within this week. So yesterday, ordinarily the court will not sit on Monday, but the case came up yesterday where the Chief of Defense Staff was in court. Lieutenant General Pepra was in court yesterday to testify in relation to documentation and some indebtedness of Mr. Jakpa while he was with the military. And yesterday was an interesting kind of event where the CDS, in fact, he came to court with, in fact, a whole squad, about 20 other military officers, including the military secretary and some other officers, stormed the court, most of them in the green outfit and all that. So he testified as a second witness for Richard Jakpa, and in fact, he's a subpoena witness in that he was invited by the court to come willingly. He was not willingly coming to testify in the matter, but upon the invitation of the court, Lieutenant General Thomas Opon-Prepra was in court yesterday to testify in relation to the reason he was subpoenaed to come to court. Yes, he made references to those 2 documents were already tendered in evidence by the military secretary when he appeared sometime 2 weeks ago. And so it was just a matter of making references to that to find out whether he is in the known of those documents, and he admitted to that. And he was taken through processes by lawyers of the third accused person, Richard Jakpa, led by Thaddeus Sorry. And one of the things that came to the fore was for him to point to the court regulation within the military regulations, things that have been said about the fact that, look, if you're an officer, there are so many conditions under which your services could be dispensed with. And with that regulation it points to the fact that Mr. Jakpa was released, or that particular clause talked about the fact that you are inefficiency and its interest. So you don't have an interest in a job that you are doing, and then because of that, you're inefficient. The efficiency level has also dropped. So that was what was quoted in the letter. However, he made references to the point that not all those things that were stated under that particular clause or that particular provisions has to do with only, or is limited to only those 2 issues. But there were other issues that has to do with misconduct. The other issue that has to do with how he was indebted to the service and how payment has become an issue. So all those things formed what they call misconduct and other stuff. So that was also, in fact, the reason he brought this very witness was to disprove the prosecution. The Attorney General's claims that he was sacked from the military because of fraudulent acts and misconduct. And if they are saying that, if you look at the letter that was written to him to sack him, it points to 2A, we talk about his interest and inefficiency. So there was nowhere that particular letter to him made references to the fact that his misconduct or anything of fraudulent. But of course, yesterday, the Chief of Defense Staff was in court, and one of the things that they said was that he was not also the one who released any confidential letter on Mr. Jakpa to the Minister of Defense, to the Attorney General, and all that. So he's done. He's been discharged. And today, like you said, Justice Ifiase Wasaribuchi is hoping that the next witnesses will appear in court. And what we are picking up is that it was not too clear because of the distractions that happened in relation to last week. The roadmap that were drawn, they had to be revised. So today, they are hoping that an officer from the Controller and Accountant General Department will come to court and testify in relation to this.
It's interesting the number of people that Richard Jakpa has decided to subpoena, to come to court to come and testify, because he's trying to prove that it was not because of misconduct.
Absolutely.
That he was dismissed from the military.
Yes.
So the Chief of Defense Staff, if you listen to his testimony, sort of buttresses that point, right? That according to the 2A,
yes,
which is the section that they refer to in
the
letter that
sacked him,
yes, it's got to do with, exhibiting the requisite skills to perform his duties and a lack of interest.
Absolutely.
But there's nothing like misconduct in there. But the prosecution's case is that he was, sacked for misconduct, and he's trying to disprove that.
He mentioned that yes, Mr. Jakpa was not honorably released from the service. That's right. How come, as we speak, if he was done honorably, his name would have been on retired soldiers, or he would have been allowed to use his rank in his civil life. So once you are released in a situation which doesn't satisfy the conditions,
you are not allowed those privileges.
Yes, absolutely. So
but if you are honorably, honorably, I beg your pardon, discharged, you are allowed to use your military title and all of that. So that's why we have captain this, captain that, captain this, retired.
So yesterday, if you ask me, lawyers of Mr. Richard Jakpa got what they wanted from the witness, and then the Attorney General, the prosecution, also got what they wanted from the witness. So it is now on the court to decide or put weight on who is making what and who is saying what, and what those the testimony of CDS will impact on whose case.
All right. So yesterday in court as well, the issue of SAL, Santro Kofi Akpafu Likpe and Lobi. We understand that the High Court in Ho dismissed the suit challenging the removal of John Peter Mewu as MP for the Ho constituency.
Yes. So yesterday,
and it's got to do with SAL.
Yes.
It's a part of the SAL petition, right?
Absolutely. So for those who remember, 2020, the people of SAL, Santro Kofi, Lolovi, Akwabi, and all, they didn't vote because of the creation of new regions and all that. So that issue had been forth and back and all. So they petitioned the High Court yesterday. Faisal Abdul Idris, our regional correspondent who was in court yesterday, to give us update in relation to whatever happened. And his report was to the extent that, look, the court listened to the parties. In fact, the applicants were led by, the petitioners were led by Chachuchi Kata, and then Justin Amenivo also represented the Electoral Commission. The court ultimately ruled that if you look at the petition that was brought to the court has no jurisdiction to deal with that particular matter, because what they are challenging is not about, they are not challenging the infractions of the election, they are not challenging the results of the election. All they are saying is that those people were not allowed to vote, and that borders on provisions within the Constitution that ought to be interpreted. And if that is the case, then they have to go to the Supreme Court and not the High Court. So on the basis of that, the High Court dismissed that particular petition, and no cost was awarded to any of the parties. The court said there will be no cost awarded to any party. So in relation to that case, yes, the petition to challenge Peter Mewu's election as Member of Parliament for Hokwe has been dismissed, because the court was of the considered view that that particular request borders on constitutional interpretation or provision, which has to go to the Supreme Court and not the High Court.
Right. We also understand that yesterday some apologies were in order.
Yes.
There was an apology from the farmer, the farmer who went to court on the anti-gay bill.
Yes.
He was supposed to file some processes.
Yes. So he's seeking.
And he failed to do so.
Paul Boama Sifa. Seeking.
That's the name of the farmer.
Yeah, that's the name of the farmer.
Right.
The plaintiff in this matter. One of the things that he's seeking was a restraining order. He's asking the court to restrain the Speaker of Parliament from proceeding with any processes related to the proper human sexual rights and Ghanaian family value bill. And what he's saying was to the effect that, look, it will have an impact on the consolidated fund. And so want that to happen, it means that a lot of things have not been properly done. And he's seeking the Speaker, he said, and his deputies and all of them to just look at, to comply with sections, particularly Section 101 of the Financial Management Act 2016 to further make his points. But of course, on the 3rd of June, Justice Ellen Sewa-Mreku, Lordina Ellen Sewa-Mreku, directed the parties, in fact, the plaintiff, to file his written submission within 4 weeks. And after that 4 weeks, the respondent, that the Attorney General and the Speaker, will also have 4 weeks to respond, which ultimately brings them to yesterday, 29th of July. And yesterday, the court was expected to fix a date for its judgment. However, when the case was called, the plaintiff, who was supposed to file first, did not file within time. It came to the attention of the court through his lawyers, led by Dr. Ernest Akun, that they only filed their written submissions on Friday, that's the 27th of July, way out of time. So now, the respondents will also have to get 4 weeks to be able to respond to that, file their reply. And yesterday, the state attorneys from the Attorney General's office indicated that they have not been served with what has been filed. So the court said that under the circumstances, the case will have to be adjourned to 22nd of October, that is the new legal year. And of course, lawyers of the plaintiff, in fact, took the opportunity to apologize to the court for not filing or complying with the orders or the directive of the court to file much more earlier. So the case will come up again in over 2 months' time after the 2-month legal vacation. And in fact, the legal vacation officially terminates after tomorrow's court sitting.
All right.
So tomorrow is 31st of July. Yes. So the new vacation begins from the 1st of August.
Okay.
Yes.
So let's talk about the recruitment scam case where military officer Captain Abel Nate.
Yes.
He was involved in the case, right?
Yes. Allegedly
involved in the case.
In that case.
But we understand he has some good news.
Yes, there's a good news for him because the prosecution indicated to the court that now they have concluded their investigation, thorough investigation conducted, and it has come to the realization that Captain Abel Nate was not involved. He's innocent. He's not involved in that particular incident which led to him being arraigned earlier. I remember that he was a subject matter of a bench warrant. First time when the case was called, the police indicated to the court that they have tried many times to even send wireless messages to the military and all that. And the military was in court the last time to disprove that, to in fact urge the court to caution the police because they're tarnishing the image of the military. Now they say that they have conducted further investigation, and upon the conclusion of the case, Captain Abel Nate is free. So the court presided over by Samuel Bright Aqua has now discharged him. So he's a free man now.
Yes. All right. So let's talk about the cases that are happening today. I mean, obviously, the ambulance trial will continue.
Yes.
But there's another leg of the ambulance trial case that
right.
we're expecting in court today. But this one is at the Court of Appeal, right?
Yes.
What's that one about?
Okay, so you notice that at the High Court, sometimes on the 30th of March 2023, over a year ago, Justice Efia Sewa Sariboche, the trial judge, made an order or made a ruling, and the ruling was on submission of no case after the Attorney General called witnesses, and then they concluded their case. The court, the lawyers of the accused persons filed submission of no case. Even if they didn't file, the court was expected to find whether there's a prima facie evidence. And Justice Efia Sewa Sariboche ruled that prosecution has made a case for the accused persons to open their defense. For which reason we have seen that 2 forcing called witnesses and currently we are seeing Mr. Richard Jakpa in the witness box also, and now calling his witnesses. But they have challenged that particular order to open their defense at the Court of Appeal. They've done that much more earlier. It is now that the Court of Appeal is ready to make a determination of that. So today, 3-member panel of the Court of Appeal will be deciding whether or not the High Court made the right decision to allow them to open their defense, or the court will determine otherwise and say that a prima facie has not been established. If that is the case, if the court decides that there is a prima facie, then what is happening in court now will continue. But if the court determines that, yes, at the closure of prosecution's case, there was no sufficient case made for the accused persons to open their defense, the Court of Appeal will truncate the trial ongoing currently at the High Court. So that is what we are expecting from the three wise men. In fact, a three-member panel of the court. So today, it's a big decision, and depending on where it will go, it will have a bearing on this very much. So it's either the court will free the accused persons today,
because their submission of no case has been successful,
absolutely,
or the trial will continue.
So that is what the accused persons and their lawyers will be expecting today from the Court of Appeal.
All right. Anas is also at the Court of Appeal today.
Yes.
It looks like today the Court of Appeal is going to be busy.
Absolutely, it will be a busy.
Kwesi Nyantakyi wants him to unmask,
Yes,
right?
yes.
And that has been a subject matter which has landed at the Court of Appeal.
Absolutely.
So what's up with that one?
So also a three-member panel of the Court of Appeal. In fact, if you come to the High Court, the reason this case has not even started, the trial has not started, is because of this very case. Justice Marie-Louise Simon has threatened so many times to discharge the accused person, but at one point in time, the court, as far as in April, the court said if by April prosecution was not ready, the court was going to discharge them, because there was an appeal pending where the processes had stalled, it was not moving. And during that day, the court said, yes, indication has come that there were challenges transferring the processes to the Court of Appeal, but all steps have been taken. However, the court said that it is minded to wait for the Court of Appeal. And what the Court of Appeal is expected to hear or to make a determination is that the High Court had made an order previously, earlier, that Anas will be a witness in the court, in the case. Their number 12 expose led to Nyantakyi being charged, and led to Nyantakyi losing his position as a Football Association president, the Ghana Football Association president, and he's in court. Anas is one of the witnesses following the death of Ahmed Swali. So Anas is now coming to testify. And the court said that if you are coming to testify, it was after lawyers of Nyantakyi filed a motion that they want to see the face of Anas before he testified. And the court said, look, Anas will come to court, go into chambers, unmasked to Anas, Nyantakyi and his lawyers. Then he will come and sit in the open court
with his mask on,
so that those of us you cannot see him, but the parties directly will see him. He says that borders on his security already. Those security that have been attached to him have been withdrawn, and so he's on his own. So that particular order from the court, he's unable to accept, for that which reason he's not ready to come to court to testify. So prosecution is challenging that order or that directive from the court for Anas to unmask at the Court of Appeal. So today, the Court of Appeal, three-member panel of the Court of Appeal will hear that particular case, and will know what the determination will be.
All right, and finally, there's supposed to be a hearing on the Gen Z demonstration.
Yes.
What's all of that about? You know, Gen Z demonstration. I think in the High Court, right?
Yes.
The police filed an injunction against the demonstration.
Absolutely. So Positive Transparency and Accountability Movement Ghana.
Gen Z.
Yes.
AKA
that is
Gen
one
Z.
of the groups. And then Arise Ghana, Bernard Mona is in there.
Okay.
The Alliance for Social
ASEPA.
ASEPA.
They are there.
It's also there.
Yeah.
So these are the organizers.
So they are the
they
Gen
say
Zs.
that they will tomorrow. In fact, the demonstration is supposed to be tomorrow.
Yeah.
They are throwing over 2 million youth on the street
Gen Z.
demonstrate against economic hardship, and that is has been said about Gen Z.
The Gen Z demonstration.
The Gen Z demonstration. And the police said that, look, 7 days demonstration, we have issues with that, and so you have to revise your route and whatever activities.
So that's why they went for injunction.
No. So the police said that is why we have the court. So we are going to court.
So was this an interim injunction or
this
an
is
interlocutory injunction?
This is an interim injunction.
Interim injunction.
Absolutely. So
right.
we are telling you, come to court, and the court will make an order. If the court says that, look, these particular steps that you are taking, the court is saying that it is not, the police is right, you have to revise, then the court will put an injunction on them and then stop them. But if the court says that, no, whatever the protesters want to do,
they have the green light to go ahead.
Have the green light to go.
Okay.
So that is what we do expect in relation to this very case.
All right, very well. Murtala, Inusah, thank you very much as always.
Thank you.
Been a pleasure having you in the studio, always updating us with what has been happening in the courts.